others will join as we move along. So good afternoon, everybody, and thanks for joining today's meeting of the ACUS Working Group on Compiling Administrative Records. For those joining us for the first time, my name is Jeremy Grayboys. I'm a Principal Deputy Research Director at ACUS and serve as the Working Group's staff counsel and reporter. As a reminder, this is a public meeting. As you heard, the meeting is being recorded and a video of the meeting will be posted on ACUS's website after today's session. Since we have a few more public attendees than usual joining this afternoon, I'd like to begin the meeting with a brief description of the Working Group's purpose and mission. So the Administrative Conference of the United States, or ACUS, is an independent federal agency within the executive branch charged with convening expert representatives from the public and private sectors to recommend improvements to administrative process and procedure. These representatives, called the ACUS Assembly collectively, have issued many dozens of recommendations to federal agencies, the President, Congress, and the Judicial Conference since its inception in the late 60s. Recommendations address topics covering adjudication, rulemaking, regulation, as well as judicial review of agency action. About 8 years ago, the Assembly issued Recommendation 2013-4, titled The Administrative Record in Informal Rulemaking. This recommendation offers best practices for agencies in the compilation, preservation, and certification of records in informal rulemaking, and generally supports the judicial presumption of regularity for agency administrative records. Recommendation 2013-4 describes 3 types of administrative records that agencies maintain during informal rulemaking. First, an internal rulemaking record that contains all materials considered by the agency during the course of the informal rulemaking. Second, the public rulemaking docket. And third, the administrative record for judicial review. Recommendation 2013-4 sets forth best practices on the contents of these 3 records, on rulemaking record keeping, on public rulemaking dockets, on record preservation, on certification of administrative records for judicial review, and judicial review itself. The recommendation also encourages agencies that engage in informal rulemaking to issue guidance to aid personnel in implementing these best practices. Some agencies, including the Department of the Interior, the EPA, and NOAA, have indeed prepared such guidelines and made them publicly available. The ACUS Office of the Chairman, which is charged with helping agencies implement the recommendations of the ACUS Assembly, recognized a need for additional advice to help agencies develop the guidelines called for in Recommendation 2013-4. In late 2019, ACUS staff invited representatives from the public and private sectors to join this working group with the purpose of developing materials to help agencies develop their guidelines for rulemaking personnel. Since October 2019, the working group has met 5, now 6 times, to discuss a wide range of legal, policy, technological, organizational, and personnel matters related to preserving, compiling, and certifying rulemaking records, including how personnel across an agency's components can most efficiently compile records on an ongoing basis, how to identify and segregate privileged or confidential information, and practical needs such as developing training materials and choosing software options. As we decided at an earlier meeting, the final product of the working group will take the form of a handbook that the ACUS Office of the Chairman will make available on its website and distribute to agencies across the federal government. The handbook is not intended to serve as an authoritative compendium of the laws and policies governing administrative record keeping or informal rulemaking. And the working group's charge has never been to relitigate administrative law, debate best practices, or provide substantive advice to agencies. Instead, the handbook will provide useful advice that agencies can use to draft guidelines that explain in a clear and accessible manner the legal requirements and policies that agencies themselves adopt for administrative record keeping and informal rulemaking. The handbook will identify topics that agencies should consider explaining in their guidelines in a way that reflects their own practices. It will also provide advice on explaining difficult legal concepts to personnel with widely varying backgrounds and responsibilities. An initial draft of the handbook was included in the materials for today's meeting, and we'll turn to that at the end of today's session. But first, let's turn to the more substantive matter for the working group's consideration. As I said before, at its previous meetings, members of the working group discussed issues related to the internal rulemaking record and the public rulemaking docket. At today's meeting, which I hope will be our final substantive meeting, the working group will turn to the administrative record for judicial review. Members of the working group should feel free to speak up at any time or raise your hand and I'll call on you. I'd ask that public attendees be mindful of the working group's need to conduct the business at hand in the time allotted. Please raise your hand if you'd like to speak and I'll be happy to call on you. So you all received a brief memo in advance of today's meeting based on a review of existing agency guidelines, recommendation 2013-4 and other materials. I identified 10 commonly addressed topics. They are, what is the administrative record for judicial review? I'll just call it the AR. And why does the agency compile it? When does the agency compile the AR? Who compiles the AR? What materials should personnel include in the AR? What materials should personnel exclude from the AR? How should personnel search for materials to include in the AR? What is the format and how is it organized? How does the agency certify the AR to the court? How does the agency file the AR with the court? And finally, how does the agency preserve the AR? So with that, let me begin with a very open question. Did I miss anything in those 10 topics that you think is essential to include in guidelines of this sort? Great. So turning to the first topic then, what is the AR and how does the agency compile it? So how should agencies define the administrative record for rulemaking personnel? I think probably compared to the rulemaking record, this is probably an easier one, but agencies have taken various approaches, tying it to the APA, tying it to Overton Park. Does anyone have any ideas on sort of best practices for explaining to rulemaking personnel with various backgrounds what is the administrative record for judicial review?
So this is Noelle Green from EPA. Sorry, I just joined. What I find useful in terms of explaining what the record is that it's the universe of information that the agency considered, whether directly or indirectly, in making the final decision. And that is as a practical point, I do say that, this is the agency's opportunity to show the court, this is the universe of things that we looked at, the good, the bad, the ugly, which still demonstrates that on balance, what we ultimately did is reasonable and well supported by the record. Of course, considered sometimes trips folks up and by the decision maker. So I kind of try to conceptualize that a little better. For example, if considered as something more than just a passing glance, and not necessarily relied on, because you can consider something without relying on it. And maybe you looked at it and was like, this study actually doesn't really do anything here, but you still considered it, right? And then in terms of, sort of by the decision maker, directly or indirectly, then that's not just the things that the decision maker physically laid eyes on, but those things that maybe the decision maker's staff briefed up in a chain to that person. So that's the way that something could be considered indirectly. So I don't think that there's like a really super neat, I think it kind of depends on who you're talking to. But I also find that sometimes it helps to say like what is not as well in certain situations. But that's sort of generally what I at least like to tell folks when I counsel them.
That's great. Any responses to that or additional thoughts? Jeff, I see your hand is up.
Yes. I noticed in your memo on pages 2 to 3, you compared the EPA's guidelines to the interior guidelines. And the EPA made a point of saying that it was this set of non-deliberative documents. whereas DOI said that the documents include the decision-making documents. So it seems like there's a little bit of, well, there's a distinction between the two agencies as to whether deliberative documents should be included in the record. And so I think that might be something that we could discuss.
Hi,
Sure.
Jim,
So,
this is Lane Nemro from the solicitor's office, and I apologize that I'm having a hard time finding the raise my hand functionality virtually on the Zoom meeting today. So I'll just jump in and thank Mr. Lubbers for his observations on that one. I similarly had a question about deliberative materials, and I would propose, with the concurrence of the group, that we table that discussion maybe until we get to the section about what should be excluded from the AR. Because I similarly have a question, particularly with regard to the price memo, and I was wondering if federal programs might be in a position to speak to that in this public forum. And then I would also note that I agree with the synopsis provided of what is the AR in pages 2 through 4 of the memorandum that you've described earlier and that Noelle sort of recited in her synopsis. So thank you.
Yeah, thank you. I think deliberative privilege, as we've seen in a few of our earlier meetings, is going to be the trickiest concept for ours to address. I would note that the DOI memo is, I think, from 2006. The EPA memo is from 2012, I believe. There's obviously been guidance coming out of DOJ at various points on deliberative process privilege itself. So absolutely, we'll definitely get to that as we get to materials to be excluded from the AR. Noelle.
yeah, so I just wanted to thank Jeff for making that distinction. That is something that I left out of my synopsis, but yes, at least from EPA's perspective, the record in the first instance does not include deliberative. It's all non-deliberative, but of course, I guess we'll get to that more substantive discussion later.
Great, thank you, Noelle. Any additional thoughts on the definition of the AR, or sort of explaining to personnel why the agency compiles it?
Jeremy, just a process point. I had a hard time clicking on the link, clicking through the EPA link to the guidance on the memo that you pushed out. So
my apologies.
Yep.
There might be a stray space in there.
Hi, this is Megan Held from Commerce. I also don't have the hand raising function, unfortunately, on the web Zoom. But I just wanted to echo what Noelle was saying and just add one of the other things I've found myself having to explain to clients is the fact that, again, not only is it just things that the decision maker considered or advisors to the decision maker considered and considering can be fairly cursory. Also, anything that was before the decision maker, that even if it basically is fully counter to the ultimate decision that was made, things that refute that, things that are in opposition to that, you can't just say, well, we didn't rely on it because we didn't think it was worth considering or something like that, which is something I've run into. Is it's not just everything that supports, it has to be everything.
Thank you. Eric.
Hi, thanks, Jeremy. Sorry, I got kicked off just a second ago. But have we tabled the deliberative conversation, or are we addressing that now?
Since you've raised your hand, why don't we address it now?
Thanks. So just to clarify for DOJ in the United States, I mean, I think, first of all, there isn't necessarily a difference between the DOI memo and the other guidance. It really depends on how you interpret the meaning of everything that was considered. I would also say that, by the way, like you could have there's a huge difference between what someone should be collecting in the agency internally during that process and thinking about for terms of litigation, and then what goes in the administrative record that is then filed in litigation as a litigation decision. So the two things are very distinct, and there may be a different process for each. And so I don't think we want to conflate the two in this process. And I just wanted to make that note. The other thing is, I do want to be very clear that thank you for pointing out that that was older guidance. And I'd note that the memo that you sent around, which was very helpful, also contains a lot of reference to old outdated ENRD guidance, which is now not the position of ENRD or the United States. And the United States has made its position very clear on deliberative materials not being a part of the administrative record in public filings, as well as not having privilege logs. And so we can identify various places in the memo where that probably needs to be clarified, but I don't think it's right here. I think up to this section, we're fine.
Great, that's very helpful. I know there have been filings in individual cases. Has DOJ released sort of public guidance on that point?
I would say that the memo does note the revision in 2017. I believe it's the Price memo.
Right.
That is the latest statement from ENRD that makes clear that that is not the position of ENRD, and that the position of the United States is that privileged materials are not a part of the administrative record. That was also in conjunction with a mandamus petition that was filed in the Ninth Circuit by the United States. Henry Price, I believe, is the name of that filing. And so you can actually read that mandamus position to see the current position of the United States.
Great, thank you. And any additional thoughts on this point of sort of defining the AR? Other questions? We've talked about how some of these definitions retain reference to the APA, to Overton Park. Is that a useful tool? Have you found that useful to sort of explain the underlying legal basis, or is that a distraction for a lot of personnel?
So this is Noelle. I found that not necessarily citing Overton Park, but at least saying, like, as a matter of law, right? When trying to explain sort of why deliberative materials are not part of the record, for example, I find it helpful to say, like, as a matter of law, because the Supreme Court has opined on this, the subjective, motivations of decision makers as documented by deliberative materials is irrelevant. And that's why we exclude them.
Mm-hmm.
So I find it helpful to kind of tie that to the extent that there are like questions about like, why wouldn't we put this in the record? And it's sort of like, well, it's deliberative and the Supreme Court has said we shouldn't. So I found it useful in that way.
Yeah. And I guess relatedly, sort of highlighting the potential consequences in court of an inadequate AR. It looks like several of these memos use different scare tactics, for lack of a better word. This is what happens if you don't compile an adequate and accurate record. Is that a useful tactic? What potential consequences are worth highlighting in these sorts of guidelines? Lane.
I found it useful, Jeremy, that the memo discussed the prospect of discovery all the way up to vacature in the event there's a question about the agency's compliance with the jurisprudential standards. So I found that to be helpful, and I think it's also instructive to agency personnel.
Great, thanks, Lane. Any other thoughts on this point or on the definition generally before we move on to the next point?
Jeremy, I also found it helpful to highlight the consequences, particularly about discovery, because no one wants to go through that. But then also there's the supplementation, which is, I guess you could say it's sort of a form of discovery, but like something a little different as well, where the court could order supplementation or completion of the record, which just means you have to go back and kind of go back through and, add things or, things like that. So I think those are also good points to highlight in terms of consequences.
Dina.
I wasn't sure if we're having our full discussion about deliberative materials right now, but I just want to note, although it's the United States position that those are not part of the administrative record, that is not the view of all courts. And it's not personally my view. I don't think I'm going to convince the United States right now to change its viewpoint in this meeting. But I would say that I would think because of that, at the least, people compiling the administrative record should be aware that the information should be compiled so that lawyers, and I think this is sort of reflected in the memo, so that lawyers can make the decision about whether it should be included, and so that the material is available if the court believes that it should be included in the administrative record or orders that there be a privilege log. So I wouldn't want there to be a situation where, you know, the court thinks that it's getting something that includes deliberative materials, but in fact, those haven't been compiled to give to the court.
Sure. Yeah, I doubt within the confines of this working group, we're going to settle the questions around deliberative process privilege. It's obviously a huge question, which is maybe a lesson for us in preparing the handbook to note that there are outstanding DOJ policies on this, and that agency should consult with their own attorneys and DOJ on compiling their own guidance and sort of table that question for purposes of the handbook. Megan.
Just wanted to agree with Adina's point. I always say I tell my clients, don't make the privilege calls. We will say deliberative materials aren't going to end up in the administrative record, but we don't want them to make those calls, particularly because it is an excellent point that it depends a lot on which court you're in. If you're in the Northern District of California, you better be prepared to make a privilege log where you wouldn't necessarily have to in other district courts, and you need to be prepared for the fact that your claims of deliberative process privilege may be read much, much more narrowly than in other courts. So yeah, it is obviously not an easy question to answer.
Right. Yeah, no, that's a great point. Obviously, these three different memos we have in front of us take three not very different tacks. They take different tacks and explaining things at different levels of detail. I think the last line of each one of them is, when you have questions, contact this person, or if you don't try to make this determination yourself, send it to your GC's office, which is probably a useful lesson in compiling the handbook as well. Lane.
I think it'd be helpful to hear from Eric first, so I don't.
Sure. Eric, go ahead.
Observations.
No, so I was just going to say on behalf of DOJ that I don't think that there's actually a big difference with what was just said about deliberative materials. Actually, it's just, like you said, Jeremy, I don't think that this project should be trying to state on behalf of ACUS who is right or wrong on the privileged material front, which is an issue that is litigated continuously. So I just think we need to avoid in the memo anything like on page 6, when we're citing, I think, perhaps outdated NOAA guidance that suggests that draft internal deliberative material should be included in an administrative record. The prior speaker made a point about you should still be collecting those things, and that may be true, but again, that is very distinct from what belongs in an administrative record for litigation. For example, people say it's not settled. If you're in the DC circuit, it is settled, and the law is very clear that those do not belong in an administrative record. So I just think we need to be very careful in this memo of not saying things like the thing on page 6 that suggest we just talk about an administrative record in the plain language of the term, as opposed to the various ways that people and stages where agencies collect administrative record materials.
That's a great point. Lane.
Solicitor's office at the Department of the Interior calls it a decision file. That is the corpus of the totality of the documents would be the decision file. And within that, we have the administrative record that would go to the court. But with respect to Dina's point, I just take a bit of exception and note that in my experience, courts typically defer to an agency's perspective concerning the completion or the totality of the administrative record. I mean, absent a showing of Overton bad faith or improper purpose, Article 3 courts are generally deferential to an agency's perspective concerning the scope of the administrative record. So I don't, typically encounter courts evaluating on a preponderance standard or something similar about the utility or the completion of the administrative record, absent some extraordinary circumstance. Thanks.
Thanks. Any additional thoughts on this point before we move on? Great. So The next question should be a bit simpler than what does the deliberative process privilege entail? When does the agency compile the AR? I think we all agree it's in the event of litigation or perhaps a strong anticipation of litigation. But what information should agencies include in their guidelines about the timing of AR compilation practices? Or perhaps it is as simple as saying in the event of litigation and leaving it at that. Megan.
I mean, obviously litigation is the ultimate trigger, but frankly, there are those times when there are decisions that you know are going to generate challenges as soon as they are issued. I was the lead attorney on a case where I was very happy to discover that the scientist working on it early on knew that there was going to be controversy about the case and put together even without being prompted by attorneys, lesson, a secure drive where he loaded a lot of the key documents, and it made our lives significantly easier because we did not have to go looking across an entire agency for some obscure research documents because we knew what had been referenced in the course of making this decision. So if it's something like that where you know where the decision is going and you know that it's going to end up challenged, and there's no real question, you should push, I think clients should be pushed to start organizing those materials just as though they were heading towards an informal rulemaking or something like that. It is possible. And then if it ends up ultimately unnecessary, as we had in a different case recently, then it's better to have that little bit of lost work than the scramble that can happen when a court gives you a very short turnaround time to produce an administrative record. For example, you're filing a motion to dismiss because you don't think it's properly an APA case, and the court says they want an administrative record now anyway.
Megan, if I could ask you, is that process distinct, do you think, from compiling what we've previously referred to as the rulemaking record? I think, Lane, you referred to it as the decision file at DOI, that sort of contemporaneous record throughout the rulemaking process. Is that a different process in cases where you anticipate litigation?
Well, I think so, only in terms of the fact that these situations I'm talking about, these were not considered rulemaking in any way, shape, or form. This was just a decision by the department, signed by the secretary. It was no sort of anything that looked like rulemaking. So that's almost sort of, it's taking people who do not think they're engaging in rulemaking in the same way, who are not looking at the same sort of Federal Register notice and comment kind of path, and getting them to align with some of those practices anyway.
Sure. Noelle.
Sorry, I could not unmute myself. So the timing question is, it can be tricky just in terms of like when the record starts. I think it's pretty clear that a record ends at the point of decision, right? At the point of signature on the final decision, right? So that's the easy part. But in terms of sort of counseling on when folks should think about, compiling the record and things like that, that the start of the record will vary according to the specific, facts at play. I'm not sure that it's useful to say like, this is, the record starts at a date certain, or like at a reference point certain in the process of whatever final decision is being made. And so what I find useful is that when we're in a posture where we have a traditional rulemaking, or even something that may not be a rule, but is another action that is sort of treated like a rule, like if there's like a permit or something, that there is still a public process associated with that, a public comment process. I think it's useful to sort of point folks to the docket and say, like, with all caveats, the docket is not required to be the record, and there are a couple very limited circumstances where that's the case. But generally speaking, your docket is arguably broader than your record, right? Because your docket is just like all public process materials, everything that the agency sort of makes available to the public in the course of their participation in the rulemaking. And whereas the record is just like what's considered, right? So the docket is arguably broader. But that being said, the docket can often be a good place to start in terms of thinking about, okay, well, we're making this decision. This is where we started the docket. The record will probably start around the same point. And then sort of take it from there. And then in terms of, sort of, we don't like to assume. I mean, I think it's human nature. You kind of want to be optimistic, right? You don't want to assume you're going to get charged and you're going to get challenged on everything. But especially if you're EPA, you probably will. So we like to say, keep an eye towards the record, even as early as when you're putting things into your docket. And so sort of have that prospective framework to work within, as opposed to being reactive to, say, a court order or the triggering of a timeline pursuant to some court rule that says, once you file your answer, for example, you have 30 days to file the record, right? And so just sort of even taking it back as far as the docket and saying, when did we start the docket? That's probably where we should start looking to start the record as well.
Mm-hmm. Helpful. Kelly.
Yeah, thanks. I just wanted to add probably more a question as to whether we should put anything in here about the timing front relating to the sort of preliminary injunction TRO issue. It seems to me so much significant APA litigation, at least over the last few years, is often decided, at least initially, in the PI or TRO posture, often without time for the agency to put an administrative record together. I don't know if we have anyone from HHS, but in the CDC litigation brought by Florida about cruise ship litigation, I think CDC submitted a declaration from one of its lead scientists, essentially walking through what I would call the administrative record, because they did not have an administrative record actually compiled yet for purposes of the litigation. I'm not aware if there were sort of challenges to the procedural appropriateness of that, but it does strike me that one of the biggest issues often in these probably the more high profile cases where there is emergency litigation is the administrative record is so crucial to the adjudication of these cases, yet I know understandably it takes agencies time to put them together. But the other factor is that often the PI decision then becomes the whole ballgame, because then, PI win or loss, there's an immediate interlocutory appeal based on the record before the district court. And so then the agency action essentially has risen or fallen, without an administrative record being compiled. So just from a very practical litigation perspective, I don't know what the solution to that is from an agency perspective, other than, maybe again, in the most high profile cases, trying to assemble something even earlier or faster, anticipating emergency litigation, but did at least want to flag that as a potential issue we might at least want to note. Sure.
Yeah, no, that's an interesting question. I mean, the challenge with these guidelines is always, who is your audience in this case? Is it best to address, if this is directed towards your sort of line personnel working on a rule, is it necessary to go into detail, or is it even helpful to go into detail about those sorts of things, or is it better to leave those sorts of questions maybe to a GC's office and not confuse line personnel in that process? Eric, I saw your hand had been up. Did you have a?
No, I was just going to say that comment was certainly not wrong in terms of the fact that is a frequent way that APA litigation happens these days. But litigating a lot of that, I can say that the courts are somewhat all over the map, and it is the Wild West because it's a TRO or PI posture. And I just don't think this committee is able to actually provide advice, like you said, to a particular audience for each individual case without saying, please check with your legal counsel.
Right. Yeah. When it comes to AR questions, maybe the best tack for a lot of these is talk to your GC's office. Great. Any other points about timing? Great. So the next question is, who compiles the administrative record for judicial review? How much detail should agencies provide in their guidelines about the various rules associated with compiling ARs and who performs them? Let's start there. what functions are involved across the agency in compiling an AR, who performs them, and to what level of detail should these guidelines get into about that topic? If I answer my own question, I'm guessing it depends on the agency and its own organization. Obviously, smaller agencies that have a centralized rulemaking process probably have a very different process than large agencies with lots of subcomponents. See one hand of applause. Any other thoughts on that point?
Sorry, I was actually trying to raise my hand, and
Oh,
I
please, go
really
ahead.
don't know what I'm doing. Well, one thing I would, sorry, this is Matt Oakes from Department of Justice. One thing I think it's also worth keeping in mind is a lot of the comments today have focused on the more formal end of the informal rulemakings. They go through notice and comments, proposals, final rules. But most agency actions, final agency actions that can be challenged under the APA aren't that formal. And I think it's fair to kind of think about the difference between the run-of-the-mill decisions that are final, can be challenged in court, but aren't, don't involve the same types of process, the same types of often years-long consideration that a more formal agency action does. And any advice that we give, at least acknowledging that reality would probably be a good idea.
Great, thanks. Jeff.
Yeah, this is just a very small point, but at the bottom of page 4, your second to last paragraph, you talk about how agencies allocate their responsibilities depending on different things. And one thing you mention is the frequency and complexity of rulemakings, but it seems like another one would be, how often they're challenged in court. An agency might have a lot of rulemaking, but if they never get challenged in court, then that would affect how they allocate their responsibilities. So just as a small point, I would add something like maybe end of judicial review to your memo.
Yeah, that's a great point. Do you centralize this in a GC's office or perhaps with a non-attorney in a docket office? Relatedly, speaking of that sort of role, I think AGUS has called it a custodian. I think NOAA calls it I'm forgetting the exact terms, but DOI and NOAA both use something equivalent to a custodian. What information, if any, should agencies provide in their guidelines about selecting an appropriate custodian to sort of manage the entire AR process?
Custodian doesn't sound like a very great title to me. I mean, I think a coordinator would be better.
Sure. Yeah, I think, Jeff, and to your point, who the coordinator should be probably depends on not only how the agency's organized, but things like how often rules are challenged. Lane, did you have a comment?
I think I'll strike my question. I'll table my question at this point. Thanks.
Sounds good. Noel?
Yeah, so when I hear the word custodian, I think of like litigation holds and things like that, which, I mean, essentially they're both sort of preservation efforts, but I don't know if that might be confusing for others. But to the point of like guidance in terms of who should be, I guess, managing the AR process, for EPA, we do say that it should be the sort of like lead, like office director or office manager that's responsible for the action, in the office responsible for the action. In other words, it should be someone that has, knowledge and some accountability to, what's going on. Because at the end of the day, you do have to certify the record. And so whoever is certifying it needs, should be able to speak to, substantively sort of what's going on in terms of knowledge of the facts and sort of how things played out, ideally. And so, but that being said, EPA is a large agency and we have many sort of moving parts. So there might also be situations where discrete programs have their own like SOPs or regulations that sort of assign a certain person the role of the AR manager. And then sometimes it's just someone in the office that with knowledge of the rulemaking that is responsible for compiling and sort of keeping things together in that respect. So I think it not only would vary across agencies, but may vary within the agency as well, depending on sort of where the rulemaking or the other the agency action would fall. So
that's a great point. Yeah, I think it was the NOAA guidance, which basically said it's important to have a person in this role. You need to figure it out in the scope of an individual office or individual rulemaking, which person is best suited to do that, as opposed to establishing a general rule across all rulemakings as to who that custodian or coordinator should be. You alluded to certification. Obviously, there are these very discrete tasks associated with administrative records. So skipping ahead a bit, we have certification, filing, preservation. What information should agencies include in their guidelines about those sorts of processes and who should do them? Or if it is performed by a specific office in every rulemaking, what level of detail is even necessary to provide in these sorts of guidelines? Megan.
I think this is a very minor point, but one thing when I compiled my first administrative record for Commerce, I discovered during the process that there is actually a form that the Commerce Department created some time ago for certifying certifying documents in general, but particularly as a cover sheet for certifying administrative records. So if you did have agency guidance and there was a form like that, I think it would be very helpful to include that, because it's just a nice, straightforward format. Because I know others who I've shared this form with have had the moment of, what are we supposed to say? What is that supposed to look like? And so it's been very helpful to just say this, it looks like this, and who is the person who has actually been pulling these documents together and seen them and have familiarity with them and can testify as to their authenticity. And just having that form there is helpful.
Yeah, that's a great point. Very simple, but it seems like it's very useful as well. Eric.
Yeah, sorry, Jeremy. I know I'm going to sound like a broken record, but I thought that what the memo said on these things was good, because it tried to stay at a high level and give sort of general principles. Because when you start to veer into the question of what gets filed by an attorney at the Department of Justice on behalf of an agency, that brings in a lot of attorney-client conversations and things that we advise our clients on. So I don't know that a lot of this would just have to say, please talk with your counsel who is representing you in the litigation, because they will have very strong views on what is required of you in a federal court.
Yeah, from my perspective, that's absolutely right. I mean, the entire purpose of the guidelines anticipated by Recommendation 2013-4 is guidelines for sort of line personnel working on a rule, not necessarily a GC's office. It's important to sort of keep that in consideration as we're developing the handbook. Any additional thoughts on these points? Great. So let's do process before we get to the contents and exclusions from the AR, because I'm assuming that will engender the most conversation here. How should personnel go about searching for materials to include in the administrative record? We obviously have talked in past meetings about an internal rulemaking record maintained contemporaneously throughout the rulemaking process. Noelle, you also talked about the public docket. When it's actually time to go about putting together the administrative record for judicial review, how should the custodian or coordinator or whatever we're calling that person go about either searching for materials or directing others to locate relevant materials? So I believe it was the NOAA guidance in this case, directs whoever that coordinator is, for lack of a better word for now, to send a memo out to any relevant program offices saying, we are now compiling an administrative record. Please look for XYZ. I think other guidance basically said that person should go to individuals and ask them, is there a sort of best practice in this space?
So I don't know that it necessarily needs to be, I mean, I don't find anything wrong with a super formal sort of memo process. You know, with the caveat that, like, at least in my role, I advise on like the legal aspects of the record and compiling it, and on our guidance with respect to those efforts. So I'm very rarely actually involved in putting together a record. There was one exception with some litigation that EPA just wrapped up actually pretty recently, that my office was the very rare lead for, where I had to actually get in the weeds and put the record together. And in that effort, like we identified like custodians in the first instance in terms of like who, you know, within the responsible offices or within the related offices, you know, would be the folks that would have access to materials that were considered in making this final decision and therefore should go on the record. And we literally just sent emails. I mean, you know, and they were very, very nicely worded and very well put together, but it wasn't like a formal sort of memo that was like distributed. That's a whole nother process in and of itself. And so sort of in the first instance, thinking about who would have, I think it was kind of in that respect similar to a FOIA process, where you think about like who would have knowledge of this, who would have documents responsive, right? But except they wouldn't be responsive, they would just be documents that were considered that would go on the record, and then alerting them, this is litigation, this is, you know, what's at stake, here are the issues. And so we're looking for sort of this, you know, this sort of high level description of things that we're looking for, and then just asking them to look for those things and send them our way if they have them. And then from there, we coordinated with our DOJ folks. But that's sort of how we went about doing it. But I can, like I said, that was just like one thing that I was involved in. So I don't know if that's necessarily how folks do it. My sort of very high level anecdotal impression is that there's probably a similar process in that respect. I suspect that sometimes we may have to pull in we have an office that like conducts email searches. That I think that happens, but I've at least gotten a couple of questions about that. So I'm assuming that that may also be something that folks do, but I can only speak to sort of what we did in my very rare case.
Sure. Megan.
Well, unfortunately, Noelle's rare case is my very common case, at least over the last few years, primarily in some of the higher profile litigations that I worked on that had very tight timelines. So I ended up, honestly, to some degree, it was more efficient for me to do it that way because I knew what we were looking for in terms of, in just general high level terms, what an administrative record looks like. So that made it useful for me to just go in and start asking questions. Who did this? Who pulled together the documents? What kind of documents were they? There were a couple cases where email became a very big part of it. One, it was because a very large portion of the record were emails with figures on Capitol Hill, so they weren't they weren't privileged, and so that just became a natural part of it. Unfortunately, that was always one person, so it made things very easy. And then in the other situation, it was one where the decision that was made, frankly, took place over such a short period of time, like 3 days, that there wasn't the same opportunity for materials to actually exist. So it was really necessary to go down into the emails to try to cobble something together for the court.
That's great. Sort of related to this question of the process for searching for materials is the question of documenting that process. I think from what I saw, every agency, the three agencies we looked at, direct staff to actually document the process for the search for documents, no matter how they actually do it. Any thoughts on that as a practice or ways of explaining that practice to personnel? Is there a form that agencies use, or is it something as simple as just document that search process and leave it to the record manager, as Jeff, as you put it, to document that process as they see fit?
I mean, again, Jeremy, this is Eric. I think a lot of that is still going to be a conversation that occurs during the litigation process, right?
Sure.
And so the attorney is going to be having a conversation about that, and a lot of that is going to be attorney-client and work product. So I think that what we currently have is probably pretty good and high level. I just worry that I don't want the agencies to have to talk too much about conversations they've had with, about cases and stuff.
Good point. Any other thoughts on this point? Great. Then I will move to the sort of last two big points for our discussion today on the administrative record for judicial review, which are what material should personnel include in the AR and what material should personnel exclude from the AR, keeping in mind that we're talking about guidelines for sort of line personnel, not necessarily for attorneys who do this thing on a regular basis, who are actually making these decisions. Jeff, you had a point.
Yeah, I know there are probably a number of issues on this in this part, but in reading the first paragraph in your memo, you talked about the record before the final decision maker at the time the rule was finalized, and then later reasonably available to the decision maker. And that raised some questions in my mind because I remember when Tom McGarity did his study back in the 80s, which later turned into that book on regulatory analysis, Reinventing Rationality. And he described these different models that agencies used in developing their rules: the hierarchical model, the team model, the outside advisor model, the adversarial model. And so I guess my point here is that it's kind of unclear who the final decision maker is. Now, the agency head often signs the rule, but that doesn't, and maybe is the official final decision maker, but there are key staff all along the route who are considering materials and making key intermediate decisions throughout. And so I find this a little bit limiting to just say the final decision maker. I'm not sure I have a better language, although the record before the agency at the time the rule was being finalized seems a little bit broader than just the final decision maker. So I don't know if others have thought about this, but there are key staff in the agency who make a lot of key decisions, and they look at studies and other things when they do that, and maybe that should all be in the record.
Yep, and that was a question we talked about with the rulemaking record earlier as well, the sort of idea of what was directly or indirectly considered by the agency head, whatever it means for the agency head to have indirectly considered something. And we had discussed at one point at what level of official and what sort of substantive responsibilities that official should have. Do those records make it into the rulemaking record or not? And I think those are all at play here as well.
Yeah, Jeremy, to that point, I mean, that if we're on page 5, what material should personnel include in the AR? I believe that you actually, this draft has included a line to incorporate that, because the following sentence says, and important substantive materials that were considered by or reasonably available to other personnel with substantive responsibilities in the rulemaking. So without commenting substantively on that piece,
sure.
It certainly seems to get to the prior point.
Great. Yeah, it seems to be that an important point in putting together these sorts of guidelines is you're directing us to line personnel who are perhaps not making the final decision as to what goes into the AR. for judicial review or not. They are organizing they are identifying a universe of documents and sending it to a skilled attorney who then makes those final decisions. So perhaps the best approach is to say overflag documents. Someone in the GC's office will figure out which documents precisely belong in the record and which do not. Eric, is your hand still up?
It is. I'll just go ahead and raise, the one comment I had on this section, which is really the cite on page 6 to the NOAA guidance. It's the second set of bullets, and it says all 3 agencies also include general principles and helpful advice. And then the 4th bullet that says materials that belong in the AR, such as drafts, internal communications, and other deliberative or pre-decisional materials that are especially significant to the rulemaking. And without commenting on NOAA's guidance, I would just note that even NOAA's guidance doesn't necessarily say that. It talks about stuff that should be included on a log versus included in the administrative record. So to the extent you're talking about, suggest, like, if you want to flag in this document that is a litigated, contested issue, and you should consider like the nature of these things and discuss with your counsel, that makes sense. But I think we want to avoid suggesting to agencies that those belong in the AR, because if, for example, you were in the DC circuit where a vast majority of this litigation occurs, that would be an incorrect statement.
Sure. No, all I meant to say there, and it could have been more clearly worded, is whether they belong in the AR, not that they do belong in the AR. But
that makes sense.
Adina.
On the same, on page 5, and this is sort of a comment I had in some places in the handbook also, I'm a little bit worried about the word important in talking about including important substantive materials, and just worried that the term important could suggest sort of a higher level of reliance than is normally considered for, what the agency has considered.
That's a good question. Yeah, I think by important, I meant something like not minimal. Thoughts on a better term to use?
I mean, I think maybe what we're getting at is relevant.
That could be, yeah.
Sorry, Jeremy, this is Eric. I'd avoid relevant just because that has a meaning in terms of civil discovery that isn't. So if you're going to stick to something, I would stick to the language in the APA, which is directly or indirectly considered or something. I know that that's bulky and not great linguistically, but unfortunately, it's the legal term.
Sure. Lane.
I would just sort of echo that point and note that relevant rather is overly broad, at least in my conception of administrative record compilation. Probative versus prejudicial seems a little bit broader or different than what we typically use to formulate the AR.
Noelle.
Yeah, so I'm wondering if we need, because you already say important substantive materials, that the final decision making considered an important substantive materials that were considered or reasonably available. So, I'm wondering if we need important or substantive, and we could just say materials, the final decision maker considered, and materials that were considered or reasonably available to other personnel.
Sure. Yeah, I think the theoretical problem, at least, would be that staff would spend eons and eons and eons looking for every single document that's potentially relevant, even if it's minimally significant. As a practical matter, is that really anything that anyone runs into?
I think it's important to not suggest that it is every relevant scrap of paper. I think we have interests, at least, in making sure that while the record is compiled in the way that it should be, that it also isn't over inclusive. So I take your point in terms of, yeah, I do think that there may be a propensity for clients to think, oh, it's just everything needs to go into the record when that's not the case. So I do take the point of like making sure that nothing is suggesting that that's the case.
Sure. So maybe some language about consistent with available resources or given other agency priorities, the sort of usual phrases.
Well, I also would caution against that only because, I mean, regardless of agency priorities and whatever else, if it was considered, it needs to go into the record.
Right.
So, you know, I don't mean to like, you know.
No.
every
Maybe
suggestion,
there
but-
is no good term, and it's
Yeah.
in the end, it's a sort of ad hoc balancing test type thing. Look for records until you're getting into minor records that sort of stuff until they add nothing to the AR. And there's no great way to explain that in simple prose.
Yeah.
Megan.
This is sort of a tangent, but looking at this has made this light bulb go off over my head regarding potential guidance that could be given to clients. One thing that if a client is engaging in like an administrative decision practice that is likely to be subject to challenge regularly and involves maybe an adversarial proceeding, but is going to require an administrative record when it eventually is appealed at, if it goes to the district court next, or specialized court next in the process. It would be good for that client to come up with some way of managing ex parte communications. Because my experience recently, I guess last year, involved a newer process that had begun with one of my client agencies, and they hadn't really nailed down the ex parte communications policy yet, and so they got flooded with emails from lobbyist groups connected with these parties that were in adversarial position to each other. And so when it eventually went up to the reviewing court, they didn't really think of these, frankly, many of them very fluffy emails as having any bearing. So they didn't, you know, the original AR compilers did not include them. But then one of the parties mentioned it, came out, there were all these communications, and huge thing, got remanded. I was the one who came in and did clean up tons and tons and tons of these really stupid communications, but all of them had to be included in the record because it was all these communications that the other side wanted to see. You know, every time you communicated with the, you know, this other party or their lobbying group, we want to see this communications in the administrative records. So since then, there is now a policy, basically no more than 3 ex parte communications, has to be very narrowly tailored, everything else. And that's just, if an agency is going to be in a situation where they're going to be having to do a lot of small, narrowly tailored administrative records, they should make sure that they cover their bases on things like ex parte communications, because that's where things can really explode if you don't.
Jim.
I have 2 questions for possible content in the report. One, is there an accepted definition of the term deliberative, and is that going to be in the report? And the second question I have, is there a dispute resolution process where if there's a disagreement among the affected parties about what is deliberative and what should be held, how that's resolved?
My own gut personally, and I'm sure others will have other thoughts, is that there's probably no way for this working group to come up with a wholly accurate and consensus-oriented definition of deliberative, and it is probably best to stay away from doing so, and note that agencies should, or rulemaking personnel should speak with attorneys if they have questions about the application of the deliberative process privilege. But other thoughts? Lane.
Can I defer to Eric on this one for the most part, but we typically focus on exemption 5 of the FOIA for the parameters of deliberative materials, pre-decisional, internal, expressing opinions or recommendations.
Sure. So directing users to DOJ's helpful FOIA guide might be sufficient for definition.
Yeah, Jeremy, you could probably do an entire other ACUS working group on what the deliberative process privilege entails.
Sure.
May I just ask Eric, and again, maybe this is a sidebar question. I conceptualize deliberative materials a little bit differently than deliberative process privilege. And that, again, may be a separate topic beyond the scope of this group. But in the DC circuit, I understand that the focus is on deliberative materials rather than the privilege.
Yes, we could probably have a long offline conversation about that as well. But I mean, that does highlight one of the hard things about all of this for the working group, which is it is one thing to conceptualize deliberative materials as part of the administrative record that is excluded because it is privileged, as opposed to, say, the view in the DC circuit and elsewhere that it's simply not part of an administrative record. But that's a very complex thing, and I think it's hard to get into that in this working.
Yeah, and it seems like multiple guidelines go to great pains to emphasize to rulemaking personnel that they should include all records, at least in the original compilation, whether or not they're privileged or sensitive. So at a certain point, it may not be necessary to get into those definitions at any level of detail. Great. Any final thoughts on what materials personnel should include in the AR, shouldn't exclude from the AR, specifically how the guidelines should or should not address these topics?
So sort of tying back to what Eric and Lane have flagged in terms of the difference between like deliberative process versus deliberative, because one is a FOIA thing, and it's weird because we borrow the definition of deliberative from FOIA, but we don't borrow deliberative process privilege from FOIA in the administrative records sphere. So in other words, you could have released something pursuant to a FOIA and therefore waive the privilege, but then the document would still be deliberative for purposes of the record, and therefore it wouldn't go into the record.
Mm.
So to the extent that obviously we want to like not go into those sort of intricacies, and I think maybe it's captured in like what you've already said, Jeremy, like, for questions about deliberative materials, consult, DOJ guidance perhaps for the definition of deliberative, but then also your counsel in terms of, because I would think that the counsel would be also, everyone's very aware of sort of that nuance and would be able to advise accordingly.
Sure.
So just to capture that, to sort of make sure that you're sort of like flagging it, but don't worry about it here. Ask you later.
These are issues. It's not your job to come up with an answer. Send your questions to this person. That approach.
Exactly.
Melissa.
Apologies, I had a little trouble unmuting myself. I wanted to ask if there's any value in addressing whether people should be instructed to put in sort of negative responses in that I don't have any of these materials that are being sought, if that is relevant and we should offer guidance on that issue of how to capture and possibly document negative responses.
Thoughts? Eric?
So again, I mean, the difficulty with that is, and this is a lot of what we have with, advice to our client agencies, and I don't want to get into that too much, but this is not a discovery process. This is something that is set forth by the APA, and our agencies work incredibly hard to comply with that. And so suddenly revealing things that were searched for and not included or that do not exist starts to get into interrogatory territory and things that were not considered part of the APA. And certainly no court has ever suggested that's required. So I don't think that the committee should get into that in this project.
Any additional thoughts? Great. So with that, I will just leave it with a very broad question. Are there any other matters related to the administrative record for judicial review that agencies should address in their guidelines, or perhaps should not address in their guidelines? Perfect. With that, I think we have concluded our final substantive conversation, and we can turn to the handbook itself, which will represent the final product of the working group. I circulated a very initial draft of a handbook based on our previous discussions. Obviously, I sent it Sunday. You have not had much time to review it. Any initial thoughts at this point? Line edits, I would ask that you just send them to me. That'll be easier to incorporate. But any high-level thoughts or initial thoughts, things you like, things you don't? Eric.
Is it possible, what you were just suggesting, to send you, Jeremy, written comments if we have any? I'm not sure that I have fully gone through the handbook as I need to. So maybe that's an easier approach.
Absolutely, that would be fantastic. I anticipate we'll have one more meeting soon, hopefully in the next month or so, to go over the handbook again and hopefully arrive at a final product by the end of the year would be my goal. So if you want to go ahead and send me any initial thoughts you have, I can certainly put those together either directly into the document if they're minor stylistic typo type things, or put together an agenda for discussion at our next meeting. Any other thoughts at this point before we break? Great. If not, then I will let you guys go 15 minutes early. Appreciate your excellent conversation as always, and I look forward to discussing again soon.
Thank you, Jeremy.
Thank you.
Thanks, Jeremy.